Okay. All right. Good morning. We are the Committee on Parole. Today's date is March the 3rd of 2026. The time is 8:42 in the morning. We're at Baton Rouge headquarters of DOC. With me on this board is Jerry Ledoux and Chuck Tillis, and my name is Steve Prater. And the staff here, would you introduce yourself, please?
Jason Thompson.
Sure.
Okay, thank you for being here and the work that y'all do. The first place we're going is East Baton Rouge Parish Prison, and we're going to be speaking to Norman Byrd. Is that correct?
Yes, sir.
Okay, what is your DLC number?
She's
93803.
Okay, all right. Mr. Byrd, I was wondering about that because we couldn't see, and I wasn't going to get into all the names, but Mr. Byrd, your case has been assigned to Mr. Tillis, who's going to go over your violations, your suspected violations of parole, and see where we stand.
Okay.
Good morning, Mr. Byrd. How are you?
Good morning.
We see that you have violated a couple of rules that we have.
Before we go over that, I failed to mention, do you have a form in front of you?
I have, yes, sir, I do.
Okay, and it talks about whether you're eligible for appointed counsel and that sort of thing. And did you sign that form?
Yes, sir.
And it shows on there you're not eligible for appointed counsel. And did you fill out that form and that's accurate?
Yes, sir.
Okay, thank you. Sorry, Mr.
Oh,
Chairman.
that's okay, good. Violation number 2, you missed several office visits or drug screenings on 6/18/2025, 7/14/2025, 8/11/2025, 10/6/2025, and 11/17/2025. How do you plead to that? Guilty, not guilty, or with a statement?
I'd like to plead guilty with a statement, sir.
Okay, let's talk about it. What happened?
At the first one, we're talking about 10 and 11, correct? Okay. I told my officer I was dirty. So he told me, oh, come back in 2 days from now and take another test. I failed it. For a month and a half, I told Miss Sarah Cobb as well that I was dirty and tried to get some help. So my parole officer told me to just come back in and we'll take a drug test every week, every Monday. And if I failed, I'd have to go to prison. If I was clean, I would be okay. So I agreed to that. That was no problem because I worked with my parole officer for 13 months. He seen me when I was doing great. He seen me going downhill extremely fast. And I talked to him about it. So he told me to go ahead and we're going to do this once a month, every week. Was fine. My son passed away at a drug overdose. I went home for a week to see my daughter. It was the second child I buried in the last 3 years. This was in the middle of me trying to clean up. I came back from my first drug test. I was clean when I went into the office. But he arrested me anyway for my past failures. But you know what? He didn't do it out of meanness. He didn't do it out of just trying to get over on me. He done it out of because he tried to help me, because he knew I could go get some help. I done 15 years in Angola. I didn't have a single write-up, not one. He knew I'm capable of doing good. I met the wrong girl and got in the wrong crowd. He even told me when I get out to move from where I'm at, because that's not a good place where I live. So I was guilty. I admit it. I'd like to go get some help. There's a place called Palmetto up in Rayville, Louisiana. I'd like to go there if possible. I've been to one rehab in my life. I'm 66 years old. I ain't trying to go to prison. I ain't trying to get in no trouble. I'm trying to get some help. The board would be kind enough to let me go there. You'd never see me in here again. Because I don't get in no trouble.
Okay. Any of the board members have any questions or anything? It seems like we need to give him some help and get into
Well,
facility.
during this period of supervision, you've already been to the Steve Hoyle program, is that correct?
Yes, ma'am, I did go up there. I did. And then I went to the store. I asked them to go to another rehab, but Miss Cobb said that the Palmetto was better. I went over to store recovery. They had just opened. And what they taught me, I never had no help. I relied upon the little help that I did get.
So SHISAC didn't help you? Steve Hoyle didn't help you?
Up at Steve Hoyle, no, ma'am. Actually, that was just a jail up there. They gave us workbooks to work, but they didn't have really no counselor to talk to us and to follow up. When I got out of store, I had to go to IOP for 3 months as well. And that helped because I was there. I had to be responsible to people. I really liked it. And I only had 28 days at store. I wound up staying there 5 months on my own. And then I got out of there and went to the counselor for 3 months after that, the IOP. And it was good because I had to be accountable and I had to go there all the time. I passed every drug test they had until November. I done good.
Have you moved from the person that you were living with?
Yes, sir. I did. My godfather died and I moved up here in Dixie. Couldn't even hardly pay the rent up there. But in November, the man I go to church with, I acquired a travel trailer from him and I moved in it. Now my rent went down to $175 a month because I get disability. I only get $640 a month. I'm not really able to work. I do a few little odd jobs. That's about it. That's why I didn't pay. I didn't have the money.
And you have completed Steve Hoyle.
Yes, sir. I completed
How long? How long was that?
That was 6 months at Stephen Hall. That was 3 years ago, 4 years ago.
And what you keep putting it back on us to find you places and make you go to places and doing that. But at what point do you have to suck it up, do it yourself?
I'd like to go.
You've had a number of opportunities in we are limited in what we can do at this point.
Yes, sir. I went to Stephen Hall and then I went to Stowe Recovery. I'd like to go to another one.
Well, I don't know that we can pay for Palmetto. I don't know. We can't. I don't think that's for educated people.
I can pay for it. I'm well covered on insurance. I have Medicare, I have Medicaid, and my own insurance.
Well, let me ask you this. You say you can pay for it?
Yes, sir.
Okay, but you violated rule number 10. You're in the rear of almost $4,000. Why hadn't you been paying
I didn't have no money. I get $644 a month. My rent was $650 until I got this travel trailer. Now it's $175. But I have Medicaid and I have Medicare, and they will pay for it for me.
How long have you been in jail this time?
71 days.
Any questions?
I don't have any question.
I don't.
If he does,
I mean,
I want to ask to go in executive session. Could you hold a minute, please? Yes.
Yes, sir.
I'll second that.
Got a motion and second for executive session and no objections. Time is 8:52. We're gonna go into executive session, discuss a procedural matter, and we'll be right back.
Oh, okay. Okay, the time is 8:55 and in the morning. Do we have a motion to go back into regular session? Okay, got a motion and a second, no objection. We're back into regular session. As I said, time is 8:56 now. We're dealing with the revocation hearing on Mr. Norman Byrd. Mr. Tillis, are you ready to vote?
I'm ready to vote.
Okay.
Mr. Byrd, you're in violation of 2 and 4 and 10. And my vote today is going to be to revoke. We've given you ample opportunities. I think you should have probably been in rehab since you were out, and you have not. So my vote today is to revoke.
Okay,
Mr. Byrd, my vote is to revoke your parole based on non-compliance with conditions of release.
okay. And my vote also is to revoke your parole violations of conditions 4 and 10. And we wish you well and all, but right now right now your parole is revoked as of 8:57 in the morning. Good morning. My name is Steve Prater. The time is 9:05. We're in Baton Rouge. My teammates today are Jerry Ledoux and Chuck Tillis, and we're here to talk about Mr. Jeremy Pollock. Mr. Pollock is in Dixon Correctional Center. Would the staff there, Warden, would y'all introduce yourself, please?
Yes, sir. Good morning, Bessie Bickham Ward.
Donald Cavalier classification.
Ashley Bradley, Records.
Alvin King, reentry. Curtis Thurman, mental health.
That's it, sir.
Okay, good. Y'all got a big roll call there. Okay, Mr. Pollock, how are you doing today?
Doing fine, sir. How are you?
I'm doing just good, doing good. Your case has been assigned to Miss Jerry Ledoux, who is on my right. And we've all read your case and all of that, but she is the lead interrogator, investigator. So she's gonna be asking you some questions. And then we're gonna have a chance to ask some questions. And so we'll go ahead and turn it over to her and let her talk to you.
Yes, sir. Thank you.
Pollock. Mr. Pollock, for the record, I would state that you're a third-class offender. You were sentenced to a 17-year sentence for theft and illegal possession of stolen items. You have a parole eligibility date of 9/11/2026, good time date of 5/29/2027, and full term date of 2039. You do have people here in support of you, your mother, brother, and the Louisiana Parole Project. Before I would ask you any questions, I would like to get the warden, if you will, Mr. Bickham, whatever you would like to add to this.
Yes, ma'am.
You probably know him better than anyone else right now.
Yes, ma'am. Thank you, and good morning to y'all. He's a trustee here, which, you know, one of our top level guys. He's a level 1 trustee. He works down there actually at headquarters on Mr. Jarvis's crew doing some work down there. So we trust him enough to go down. He's done a tremendous amount of classes. And then I think he's been over a little 4 years roughly. He's been locked up. He has had no write-ups at all, which is impressive. And besides the classes, some of the classes he's been through, Malachi Dads and different ones like that in the STAR program. He is, I will say he attends church regularly and he does represent the faith well around here. So he does that. So that's pretty much it. He's a pretty good guy.
Could classification tell me if he's completed pre-release?
I think completely. He's currently enrolled.
Currently enrolled. Okay, great. That's one of the questions I had. Mr. Pollock, you were on probation when this occurred. Is that correct? And you were revoked?
Yes, ma'am.
Okay. Well, you do have your mother. I'd like for Miss Cheryl Pollock to speak first. Miss Pollock, you can just tell the panel what you would like us to know.
Yes, ma'am. My name is Cheryl Pollock. I am Jeremy Bryce Pollock's mother. I'm here today to speak on behalf of a favorable outcome for Jeremy in his parole hearing. Since birth of his oldest son, Waylon Bryce Pollock, Jeremy has displayed excellent parenting skills. During his incarceration, he has spoken to one or both of his sons almost every day on the phone. Since both sons are under my guardianship, Jeremy has been able to maintain a close relationship with them. He's been able to keep up with their academics and sport events for both boys. During Jeremy's incarceration, I have observed continual personal growth. He has learned numerous skills at his assigned jobs. He has earned money with his hobby crafts and has purchased numerous tools to use in the hobby shop. These skills and tools will enable him to do maintenance and remodeling on the 3 houses that I currently own. I also have seen emotional and spiritual growth as he has participated in numerous good time classes, as well as available church services at his facility. I truly believe my son has worked hard toward his rehabilitation. He has passed all of the random drug tests that have been given to him, as well as maintained a spotless record with no write-ups or infractions during his time of incarceration. Jeremy's drug addiction caused him to commit crimes that I believe he would not have committed had he been sober. I believe that he has sincerely worked on his addiction and will continue to work on personal growth in order to maintain a profitable and sober lifestyle. Jeremy has convinced me of his remorse and has apologized numerous times for his guilt in the charges that were brought against him, which led to his incarceration. I am willing to allow him to reside in my home with his 2 children upon his release. I am looking forward to reuniting our family and allowing him to help me finish raising his sons to be strong, law-abiding young men. Thank you for your time.
Thank you. Your support is critical. We also have Ben Pollock, your brother and the victim in the crime. Mr. Pollock, if you would like to speak.
Yes, good morning, members of the board, and thank you for this opportunity to speak this morning. My name is Benjamin Pollock, and I'm Jeremy's brother, and I was also the victim in the case that led to his probation and parole being revoked. In August of 2020, my ATV was taken from storage by Jeremy, and I first gave him the opportunity to return it without formal charges being filed. And when that did not happen, I reported the matter to law enforcement in Vernon Parish. And at that time, I made it clear to them, as well as the district attorney's office, that I was not acting out of a personal vendetta, that my concern was accountability. And I believe then, and I believe today, that if a person will take property from family and justify it by saying, I needed it, that they will take property from anyone. And I don't believe that respect begins and ends in the family, but I believe it begins there, is taught there, and is meant to be lived outwardly in society. And so that kind of behavior cannot be excused. It must be corrected. However, when the charge was filed, I asked only for the minimum necessary to obtain a warrant and recover my property. And the decision to pursue felony charges was made by the district attorney and sheriff's office due to post-hurricane circumstances at that time. And I respected their judgment then, and I respect the justice system now. During the pretrial discovery phase, I was asked by the district attorney's office for any recommendations that I might have regarding potential sentencing. And I said that my goal was accountability and deterrence, and that I trusted the justice system. And when probation was granted, I did not resist that or resent it. My position has remained consistent over the years, that actions have consequences and lawful living is not optional. However, accountability and restoration are not opposites. Accountability is the pathway to restoration. The purpose of consequences is correction, and I pray that the consequences have been felt and understood. And if Jeremy's institutional record reflects compliance, and if he's completed required programs and demonstrated lawful behavior, and it sounds to me like he has, then I have no personal opposition whatsoever to his release. My brother is nearing 40 years of age, and at some point, a man must either remain defined by his worst decisions, or demonstrate that he has learned from them. And my hope is that Jeremy has decided to put his past far behind him and live that decision out in practical, everyday life, if given the opportunity to do so. I'm not here today to minimize what happened. I'm here to say that I do believe accountability has occurred and time has been served. And as a minister of the gospel, I do believe that by the grace of God, it's possible for a person to move away from their past and become a productive member of society. And my hope and prayer is that I will see my brother living in freedom again and living responsibly very soon. And thank you again for your time, and thank you for the work that you do.
Thank you. We also have Channing Blake with the Louisiana Parole Project.
Good morning to this honorable board. Channing Blake with Louisiana Parole Project, appearing on behalf of Mr. Jeremy Pollock. Due to his faith-based participation, the classes he's taken, he's been write-up free. Him being a trustee and many other factors, he's been accepted into our program. If this board deems it necessary to grant him parole, we're committed to his reintegration into society. He'll participate in our intensive reentry programming and services. He'll be given transitional housing. He will also be assigned a reentry specialist and a mentor that'll guide him through the reentry process. So today we ask this honorable board to give him a favorable recommendation. Thank you.
Thank you. Mr. Pollock,
Yes, ma'am.
420 days. Let me tell you what I noticed is the 4 different types of substance abuse treatment programs that you've taken, which you recognize you had a drug problem.
Yes, ma'am.
What are you going to do? You are granted parole to maintain your sobriety and stay away from illegal drugs. And by the way, marijuana is an illegal drug. Okay. So I just want to make sure you know that.
Yes, ma'am. Absolutely. Marijuana is an illegal drug. I agree with that wholeheartedly. At my time at DCI, in which I believe that the Lord had charted my path here, because this place at DCI offers everything that a man needs for his rehabilitation and recovery process. And I'm sorry I'm having such a hard time right now, but with that being said, my classes that I've taken here, that I've never had an opportunity to learn the valuable information, not to take away from any faith in God, but the programs and rehabilitations that I've been to have all been faith-based. And but here, through the classes that Department of Corrections have instilled in prisons to offer, as far as NA and AA meetings and Malachi Dads and substance abuse and the STAR program, I have learned the proper tools that I need. And to answer your question, I have learned 3 different attitudes of awareness, staying surrendered to my higher power, which is my Lord and Savior, Jesus Christ. And I've learned an attitude of growth. And those will be 3 attitudes that I have to keep for the remainder of my life. I've also learned that without drugs, it gives me an opportunity to function as a useful human being. And I'm given that opportunity every day as a trustee to come down to Baton Rouge and work at DOC headquarters and do the things that's asked of me and complete the construction projects that's asked for me to do. And that gives me such a sense of belonging in this world. And I believe that a man can only have that sense of belonging if he stays living a life full of sobriety. I can also tell you that I've learned through my NA and AA meetings that any clean addict is a miracle. And as of today, I've been clean for 44 months and 17 days. And I can tell you that my commitment to staying clean and living sober will not change
in the event that I'm granted parole and I'm allowed to be a productive member of society. And in this 44 months and 17 days, I've learned to know what true happiness and joy and freedom is. That's what the classes that I have involved myself with and taken voluntarily. And I can just say that all of this is in part to the Lord, because as I attend the faith-based programs that they have here, and I don't know if I should say this or not, but the warden here has allowed the Spirit of God to move at this prison. And it has helped me tremendously. And when I read my Bible, I see in the King James Version, it says in John chapter 8 and 36, if the Son therefore shall make you free, then you shall be free indeed. And I truly believe that through God being the source of giving the DOC department and helping them implement classes and programs and meetings for men to take that are in prison, I believe that if a man truly prepares himself and as far as preparation is concerned, that he'll be able to deal with different feelings of things that are of nature. So I say that as a man sitting here today in front of you, I have truly prepared myself through my classes and programs and meetings within and my religious and faith-based programs. So to answer your question, ma'am, I believe that I'm ready, and I believe that I've done the things and acquired the things that are going to allow me to be a productive member of society again.
Well spoken. I don't have any other questions. Do either of my colleagues have any questions?
I don't have any questions.
No question.
I'm prepared to vote. And I will say I appreciate your heartfelt remorse and plans for the future. I base my decision on evidence, and the evidence indicates that you pose no significant public safety risk. You have no opposition, and have done your rehabilitative work, and you have excellent conduct and plans for reentry. So based on that evidence, my vote is to grant parole today.
Mr. Gillis?
I concur with Ms. Ledoux.
Okay, and I concur also. So as of 9:23 this morning, your parole has been granted. Thank you.
Thank you.
It's still 3/3 of 2026. I'm the chairman this morning for the Committee on Parole. We're in Baton Rouge. To my left is Chuck Tillis. To my right is Jerry Ledoux. We're here to talk to Mr. James Mitchell, who is at CADDO Correctional Center. Mr. Mitchell, is that you I'm looking at on TV?
Yes, sir.
Okay. What is your DLC number?
411770.
Okay, and you got a form in front of you, I'm sure, but it allows you to choose whether you have an attorney or not. And I see you do have an attorney. We have Mr. Eric Johnson, who is here all the way from Caddo Parish or Bossier Parish, Webster Parish, and anyway up north, and he is here to represent you. So having said that, before we get into the case, the case is Miss Jerry Ledoux's. Well, tell you what, I'll just turn it straight over to her and let her talk to Mr. Johnson and see where we go from there.
Okay, Mr. Mitchell, you already settled the issue of having an attorney, so I don't need to go there. You've been accused of violating 2 conditions of your parole. Condition number 4 says that on or about 9/19/2023, you committed the offense of simple burglary, 3 counts, and was arrested by Caddo Parish Sheriff's Office. These charges are still pending, and arguments and hearing is set for April 6, 2026. You are allowed to enter a plea of guilty with a statement, or not guilty, and you may defer to your attorney for assistance in making that plea.
Okay. So we would ask to enter not guilty plea and spoke with Mr. Abbott. We may have a resolution to Mr. Mitchell's charges in Caddo, which I think is the main basis of the revocation. When he goes back to court on April 6th, if I could request a continuance some after April 6th, we may have an easier decision, you know.
So, Mr. Johnson, are you saying that you believe these charges will be dismissed?
But I've spoken with the assistant district attorney about is a dismissal of the charges if a sum of restitution is paid. That's correct.
Okay, because, you know, we don't look at necessarily, we look at violation of parole conditions. So if he was involved in illegal. Okay, so you're pleading not guilty.
Yes, ma'am.
And we also have violation number 10 in that he is in arrears of $590 in supervision fees. How would you plead to that?
Guilty.
The review of the file, for me, it was evident that there was a crime and that you did commit from the evidence, a burglary. Tell me about your conduct on parole other than that incident. Do you have any other problems?
No, ma'am.
Were you working?
Yes, ma'am.
Okay. So, if you're working, tell me about the lifestyle that would put you in a position to be stealing things, even though you're working. What's going on?
I took on too many responsibilities and got overwhelmed.
So you were actually paroled. You were a parole case.
Yes, ma'am.
Gift of parole. Because you have a full term date of 5/2/54. You're a 3rd class offender.
Yes, ma'am.
A lot of people want a second chance, and I get that. You were given the gift of parole.
Yes, ma'am.
So were you having any kind of substance abuse issues?
Toward the end.
So what precipitated this? What was the trigger that got you where you are? Be honest, I need to know so I can determine what to do.
I got overwhelmed with all the responsibilities I took on with,
Tell me about the responsibilities.
like I bought me I was working on getting me a house, and I had so many bills and so many things that I couldn't, I had a family to take care of, and we were just lose everything. And
Are you married?
no, ma'am,
How many children do you have?
I have one. I have a daughter and a grandchild.
I mean, I have pictures and everything. Crying. Mr. Johnson, do you have any statements you would like to make on behalf of your client?
I think what Mr. Mitchell said, sums up why the conduct occurred, that, he overloaded himself with, financial obligations that he could take care of through his job. And that led to, I think, relapsing into substance abuse. And that's where the acts occurred.
Okay. So, Mr. Mitchell, you were on drugs.
Yes, ma'am.
You have a drug problem.
Yes, ma'am.
Have you had, how many years did you spend, before you were paroled, how many years were you incarcerated?
12 years.
Did you have any substance abuse treatment while you were incarcerated?
Yes, ma'am.
And what was that? What kind of treatment?
AANA and Celebrate Recovery.
Okay. Panel, I would defer to you if you have any other questions.
I have no questions.
Okay, this is and what offender, I was looking for your offender class. What offender
The
class?
third class.
Third class offender. Mr. Mitchell, I know you got a very capable attorney here, but sometimes it gets to the point of no matter what the representation is and all that, but you just a slow learner.
Yes,
I mean, how much more can you expect us being the taxpayers and the citizens of Louisiana to put up with from you? That's what bothers me, whether you make restitution or not, whether they drop the charges or not. The point remains, it's pretty evident that you're involved in criminal conduct again. And that's what bothers me. Why? Why are you such a slow learner?
I don't even have an answer for that, to be honest. You're right. You're absolutely right. It's all about who you surround yourself with. And I just surrounded myself with the wrong people. And
Well, some of them here last week and they said you were the wrong person. You know what I mean?
that's my,
Yeah, okay. Not just about other people.
Yeah, it seemed like from what was in the record here as far as the Facebook posts and things like that, that y'all were all pretty wrong. Y'all like bad chemistry.
yes, sir.
Y'all bad for each other. Not just, you can't blame it on them.
Yes, sir.
Okay, I think if that's all, are you prepared to vote for, and of course, we have the choice of a continuance, do not revoke or revoke in lieu of.
I'd ask to go into executive session.
Okay,
I'll second.
we've got a motion and a second to go into executive session for just a minute to talk about some procedural matters. The time is 9:36 in the morning. We'll be off air for just a few minutes and we'll be back in just a moment. Okay, the time is 9:40 in the morning. We've been in executive session. Could I have a motion and a second to come out of executive session, go into regular session?
Session.
Got a motion and a second, and there is no objection. So at 9:40, we are out of executive session into regular session and still considering the case on James Mitchell on a revocation hearing. Okay, this case has been assigned to Ms. Ledoux. I think we've had our questions and we discussed some possibilities back on procedural matters, but I think we're ready to vote now.
Mr. Mitchell, the role of the Committee on Parole and Revocation is to determine if there is evidence that you have violated your conditions of parole and to make decisions based on that information. And the evidence clearly shows me that you have violated your parole and that you should be revoked today. So my vote today is for revocation based on your admittance and the evidence that I see.
Okay, Mr. Tillis?
My vote also is to revoke for rule number 4 and 10.
Okay, and Mr. Mitchell, I'm like my panel. I feel like you've been given so many bites at the apple. The only thing left is the core. And my vote also is to revoke you, violation of conditions 4 and 10. And therefore, as of this morning at 9:42, your parole has been revoked.
Yes, sir.
Good morning.
Good morning.
My name is Steve Prater. I'm the acting chairman this morning of the Committee of Parole. We're in Baton Rouge. Time is 9:50. We've introduced ourselves. We're talking to Mr. Travis McKay, I think. Is that correct?
Yes, sir.
Okay, Mr. McKay, is there any of the staff in the room with you?
No, sir.
Okay. What is your DLC number?
462614.
Okay. Do you have a waiver in front of you that you signed that about this particular hearing that we're in today? Yes, sir. I think that's probably it. That talk about an attorney and that you're not eligible for an appointed attorney.
Yes, sir.
Okay. And you're ready to proceed this morning, correct?
Yes, sir.
Okay, thank you. All right, well, your case has been assigned to me, and when you get out of jail, when you get out of prison, you sign a sheet that says you'll abide by these number of conditions. And the conditions, if you violate those, then we have to have a hearing to find out if you truly violate it or not. And so you're accused of violating conditions 4 and condition 10. You've had a preliminary hearing and they determined there was probable cause to believe that you did. We're here to make that final determination. Let's talk about number 4 first. Is it true that you pled guilty on 12/11 of 2025? You pled guilty to domestic abuse, first offense, and for violating a protective order. Is that correct?
Yes, sir.
Okay, and you got 6 months in jail. They were to run concurrent, and let's see. I think that's about all there is to it. You want to tell us about anything else about that other than you pled guilty to having violated that?
Well, I pleaded guilty because I was because of my background. I didn't feel safe going actually to trial with the case, even though, but you know what I'm saying, I feel like it still was possibility that the jury might find me guilty because of the way the DA might proceed it. But other than that, you know what I'm saying, the reason why I'm not denying the fact that my plea of guilt to a misdemeanor, you know what I'm saying, is still a violent charge. So I understand there's a possibility that the board still can find me in violations of my conditions. But at the same time, the reason why I wanted to come and speak with the board because of my situation upon my release. The victim in my case was where I was in a relationship, though I was located, that's who I was living with. And since I don't plan on being with the victim upon my release, I was asking the board if possible that I could be asked for some help from them because of the fact that when I get out, by me not being with the victim, I'm not gonna basically have a resident. I'm from Shreveport. I come here from Shreveport looking for a better chance to get off around what I'm basically trying to get off around what I know, and which has always kept me in trouble. I mean, everything was easy access to me. So therefore, you know what I'm saying, by me coming here, you know what I'm saying, that was my process of trying to better myself. And like I said, upon my release, if I was to release today, you know what I'm saying, I won't have nowhere I'll be basically homeless upon my. So I was asking the parole board, even since I'm gonna be in violation of my parole, or if they're gonna see me in violation of my parole, okay, which is I have like a year and probably a month left on parole. Upon the calculations, DOC would probably be like a remainder of 5 months at the most. So I was asking parole if possible. I mean, if the board, if possible, they could place me in a road release process in the program for at least 6 months, or the remaining of my sentence on my parole. Therefore, upon my release, I at least had the opportunity, you know what I'm saying, to obtain a job that I might that possibly be working at, you know what I'm saying, the way I already, forced me releasing, I've always had problems with trying to get back in, get comfortable back with society and go force going like to companies or whatnot, putting the application, even though most of it's online now. It's like I have a hard time like coping with society, trying to get myself back comfortable with society. So I know if I, sorry.
Okay, let's slow down a minute. Do I understand you right in saying that you are willing to voluntarily revoke yourself?
I mean, it's possible. I say I feel like the board is gonna do it anyway, but at the same time, like I said, I don't have no reason to go on to. But 5 months, I feel if they can give me the 5 months in the road release program, that way I can try to culminate something. So when I get out, I won't have to just walk back out there with nothing. Yes, sir. I'll be willing.
Well, you kind of putting us in a bind here.
Sorry.
Okay.
Yes, sir.
Let me ask you something. Did you call this woman 117 times?
Yes, sir. Probably more, but when I first got here, we was in the process of her trying to bum me out because she didn't feel that she wanted, because she basically stated to the officers herself that she wasn't pressing charges on me. But no, saying by being I mean, whatever for whatever reason, they said the state pick it up, so they press charges themselves and whatnot. But no, I'm saying we was in the process when I first got here. I wasn't familiar with the fact that I was on a protective violation, so I was contacting them from the start. And once I did find out about it, we was in the process of we trying to bond out. And it was in my mind then. I was like, if she gonna be getting me out, you know what I'm saying, I didn't mind pretty much violent, even though I knew it was no.
Okay.
Yes, sir.
You got a lot of words in your body, don't you?
Yes, sir. I mean, yes, sir.
Okay, let's I think we got that straight on the domestic violence thing. You pled guilty to it. You pled guilty to violation of protection order. You called her that many times. And the condition number 10 says that you owe $1,071. Is that true or not?
Yes, sir. I mean, it was like 300 something when I first got arrested, but I guess they added my incarceration time.
Yeah. Okay, and so what you're wanting to do is revoke yourself, providing you can go to work release.
Yes, sir.
Okay. And that, I think we passed. I think that horse is out of the barn, I believe. I think it's gonna be our decision to make. Does the board have any questions there?
I have no questions. You're gonna get the officer there to sign in. Or doesn't matter.
Yeah.
I'm sorry,
What was your name?
Deputy Exnicious.
Okay, thank you.
You're welcome.
Okay, Ms. Jerry, you got any questions? Okay. Mr. McKay, it's up to me to vote now because we don't have any more questions. And I think that's great that you want to go to work release, but you're gonna be getting out in a little over a year anyway. And being a sixth class offender, I don't know that to reward you with a work release would be, the most we can do is in lieu of revocation, put you in a 6-month work release. And I think because of the violations that you have and because how many times have you been on supervision before?
I guess I got like probably 6 convictions. And every time I come home, I'm still basically on the supervision.
You get revoked every time you get on?
Yes, sir.
Okay. All right. My vote is to revoke your parole today and make you spend some time and be accountable for what you did. That's my vote.
My vote is to revoke based on violence against another person during your period of supervision.
My vote is to revoke for rule number 4.
Okay, as of today at 9:59, your parole has been revoked because of violation of conditions 4 and 10. Okay, thank you, sir.
Yes, sir.
Toby James. I'm gonna tell me everything to look from little now. I say you have it. There you go. And the people work for BREAUX, huh? Oh. And how people work for BREAUX? Oh, there's a bunch of people, man. I think. Check them, they came up. Good.
Yeah, this is telling you who's next in line out there. Yep.
So they have us muted on their side.
Yep. Yep, because when they come up, what they'll do is we can unmute it from this side, but generally they unmute it when they're ready to talk.
Okay.
Good, see right here.
Okay.
Good.
All right, we're ready.
Right. Good morning.
Okay, good morning. It's 10:02 in the morning. We're in Baton Rouge. This is the Committee on Parole, and we're gonna be hearing the case of Mr. Toby James. And my name's Steve Prater. To my left is Mr. Tillis. To my right is Ms. Ledoux. And we're going to be talking to you about your revocation hearing. Mr. Toby James, is that you?
Yes, sir.
And what is your DOC number?
424991.
Okay, do you have a form in front of you that you signed
Yes, sir.
okay, it says, and you signed that and you understood that form about attorney and appointed attorney and all this sort of thing, and that you weren't eligible, but you could hire an attorney if you wanted. You understood that?
Yes,
Okay,
sir.
this has been assigned to Mr. Tillis, but before we go there, is there anybody from Vernon Parish Jail that is in, would you introduce yourself, please?
Yes, sir. I'm Captain Williams.
Okay, thank you for hosting us today.
Yes,
Mr.
sir.
Tillis, I think I'll turn it over to you and.
Okay. Good morning, Mr. James. How are you doing?
I'm doing good.
We have you in violation of rule number 4. You committed the offense of aggravated assault and was arrested by the Lee's Police Department on 11/5/25. These charges were dismissed by the 30th Judicial District Court, District Attorney's Office on 12/18/25. How do you plead to that charge?
Not guilty.
With a statement?
Yes, sir. It was he put a false statement on it. He was talking to my stepdaughter, and I just was talking to him, and he said I pulled a knife on him, and I never did. And I couldn't see my parole officer in him, and that's where the city come up there. But I never pulled a knife on him or nothing like that. I mean,
It was said you had 2 knives. Did you have 2 knives with you?
no, sir.
You didn't have any knives with you?
No, sir. I just come in from work to go see my probation officer the same day. I had no knife on me or nothing.
Okay.
Then there's cameras all around my apartments. And so when I went to court, I ran the cameras back and seen I had no weapons or nothing on me. And so the judge dismissed everything off of me.
Did you, what was he angry with you about?
Because he was trying to talk to my 15-year-old stepdaughter. And I come in from work and told him that she was too young. And we were just sitting there talking, and he got mad. He was trying to put me out. He knew I was on parole. So he called the law on me, he can put me in jail. So that's what he did, just to get me out of the way. But I never pulled no knife on him or nothing like that. I mean, basically I went to court and they'll see it on camera and stuff. I never pulled a knife and dismissed the case. And then I went to arraignment, and that was it, sir. I never went to trial or nothing like that.
You're a 4th offender?
Yeah, yes, sir.
Okay. I have no more questions.
Mr. James, how was your conduct while you were on supervision?
It was good, ma'am. I reported every month. I passed all my drug tests.
I caught up on my payments and I was working moving trailers.
I didn't note any violations while you were on supervision. So you must not have, this is because it's a crime against a person that they held you and didn't do a technical violation.
That's right.
You've been detained since December 25.
Yes, ma'am. Tell you what, I got arrested November 3rd for the charge, but I bonded out and went home for a whole month. Then they come back and rearrested me in December. So I bonded out on the charge.
They rearrested you because you were on parole and it was a crime against a person.
Yes, ma'am. But I got that my probation officer the same day that he said I pulled it out, and they knew I was, on probation. They the one brought me over here to the sheriff's office and never put a hold on me. So they let me find out in December. They come back and said, well, we made a mistake. We're supposed to put a hold on. So I don't know where I was out working.
Okay, so have you been clean? No substance abuse while you've been out?
No, ma'am. I've been clean. I've had all my drug tests and alcohol tests and everything. I've been working and trying to get my life back straight. You working for me too. And I work for Mr. Williams there at Vernon Jail. I'm a trustee over there.
So what do you do when you were out? What kind of, you were moving trailers, right?
Yes, ma'am. Mobile homes and stuff.
Uh-huh.
And I was filing for my disability because I hurt my knee. So, but I was working on the side.
Well, any injury like that can lead to drug abuse. You got to be careful.
Yes, ma'am.
Oh, maybe a question.
You said you didn't have 2 pocket knives?
No, sir. I went in my probation officer, they searched me, put everything out of my pocket, and I never had no knife.
But did the probation officer go out in your car and or your truck and get 2 knives out of the glove box?
I don't know, sir. I mean, I ain't.
Says in the report he got the 2 pocket knives out of your glove box and put them in evidence.
I ain't got a report on none of that. And it's none of that.
You would know if it happened, wouldn't you?
Yes, sir.
Did it happen?
But they went and searched my vehicle, come get the found out because the seat was there.
Did you know they got 2 knives out of your vehicle?
No, sir.
Okay, well, they did.
Yeah, that's for the 2 knives.
See, I'm kind of bothered by the fact that I had to drag that out of you.
No, sir. I ain't got no knife. I don't know if they pulled a knife out, but the city was there. The city arrested me, and all they charged me was that. There's none of my paperwork saying I had a knife. I mean, all my motion and scrubbage they gave me, it showed that I ain't got no knives. I mean, they didn't tell me none of that.
Well, they shouldn't have to tell you. Did you have 2 knives in your glove box?
No, sir.
You didn't?
No, sir. I didn't have no knives, no weapons or nothing.
There's a search of the vehicle. You 2 pocket knives found in the glove box of the vehicle. Both pocket knives were confiscated, placed in an evidence bag, and this is parole officer that's saying that.
Oh, no, sir. I ain't seen no knives. That's honest to God truth. It's nowhere in my motion or scrubbage or nothing. If they had found a knife in there, I wouldn't have lied about it. I'd told you, yes, sir. But there's no pictures or nothing of a knife they found. And it ain't in none of my paperwork that they found a knife. So, I mean, I don't know. I ain't calling them a liar or nothing like that, but I ain't got the paperwork saying there was a knife.
I don't have any other questions.
You ready to move?
Okay.
Mr. Mr. James, my vote today is going to be to revoke for rule number 4. Yeah.
Okay,
My vote is in lieu of revocation to send you to a transitional work program for a period of 6 months. I don't think that you've been totally honest, but, about the knives, but, I think that would be in the best interest. So that's my vote.
okay, thank you. And my vote, I concur with Mr. Tillis. I think because of violations of 4 and 10, that your parole should be revoked today. And, as of 10:12 this morning, your parole is revoked. Thank you, sir.
Yeah,
Okay, good morning. My name is Steve Prater. I'm on the committee of parole for the state of Louisiana. With me is Jerry Ledoux and Chuck Tillis. We're in Baton Rouge. The time is 10:31. The date is 3/3 of 2026. We're wanting to speak to Mr. Michael Coffey at Sabine Parish Detention Center. Is anybody in the room with you, Mr. Coffey, from Sabine Parish? And would they introduce themselves, please? You're on mute, please, sir.
Can you hear us now?
Yes, sir.
Sure, thank you.
Okay.
Introduce himself.
Did you introduce yourself, sir?
Sir, my name is Deputy Hensel.
Okay, thank you, Deputy. And Mr. Michael Coffey, is that you I'm looking at?
Yes, sir.
And what is your DLC number?
721795.
Okay. Do you have a waiver in front of you that you signed that says that you talks about an attorney and that you could have an appointed attorney? You couldn't have an appointed attorney unless you fit certain criteria.
Yes, sir.
And do you fit that criteria?
Yes, sir.
Okay. Did you understand my question? Did you hire an attorney to represent you?
No, sir.
Are you eligible for an appointed attorney?
I'm not sure.
Okay, well, you signed the paper. Can you read and write?
Yes, sir.
Are you on drugs?
No, sir.
Are you mentally unstable, or is anything wrong with you mentally?
No, sir.
Not under any treatment or medicines or anything like that?
No, sir.
Okay, well, you're not eligible for an appointed attorney. So we'll go ahead and have the hearing now. Are you ready to have the hearing?
Yes, sir.
Okay, all right, good. Mr. Tillis, I'm gonna turn it over to you, since it's your case.
Good morning, Mr. Coffey. How are you?
Good morning, sir. How you doing?
Good, good. You're in violation of rule number 4. You failed to refrain from criminal activities. You were arrested on January 27, 25 for the offense of second-degree battery. You were billed with charges of second-degree battery under docket 84998 on November 13, 2025 in the 11th judicial docket. You pled guilty to this amendment charge of simple battery and was sentenced to 6 months in the parish jail with credit time served. How do you plead guilty? Guilty with a statement or not guilty?
Guilty with a statement.
Okay, tell us about it.
It was self-defense. He come in there and he told me that he was gonna kill me in my sleep, and I tried to get away from him and I had no choice.
You had a gun?
No, sir. This was in jail. This happened in jail.
It happened in jail?
Yeah, he was locked up.
Okay. And so what did you do?
I just hit him one time and walked away. Like he.
Okay. And I have no more questions then.
Mr. Chair, good day.
Mr. Coffey, that's not exactly what the write-up said, that you hit him one time and walked away. He in fact had a broken jaw.
No, ma'am. That's why it got dropped down. They told me in court that it was not broken.
Okay. He had to receive medical treatment. Okay. So you were incarcerated while this happened. Do you still have to answer to your forgery charges in Jasper?
No, sir. No, ma'am. All that's complete and finished.
Okay. Okay. I have no further questions.
How long have you been incarcerated now?
Well, I've got out on my forgery charge, and I did 21 months, and I came here, signed up for parole. I had a warrant in Texas, and then I've been in jail ever since January 13th of 2000. 2005. So I've been in jail going on 14 and a half months.
I have no questions.
Let me get this fight straight in my mind. It was over somebody that said that they were going to kill you in your sleep?
Yes, sir. He come in there, and I've been to jails where I seen people get beaten in their sleep and get stabbed in their sleep. He come in there talking noise, told me he's gonna beat me up in my sleep and kill me if I sleep. And I asked him to leave, and I tried to leave. It didn't happen. I hit him one time, and I stood over him, and it looks like I hit him more than once, but I only hit him once.
Okay. Why was he gonna kill you in your sleep?
It's somebody I knew off the streets a long time ago. I had a problem with through in school.
And what about raping your wife?
That's all. That's all him. That's what he said.
That's, I mean, that's what did you not say that? It's the reason that you did it?
Like, he sat there and told me he's gonna kill me in my sleep, and he talked about my family. Yes, sir.
He said he was gonna rape your wife, right?
Yes, sir.
It's a strange deal here. Did you claim that he had raped your wife already?
No, sir.
That's what the parole officer said, that the deputy said, so it's kind of hearsay. So are you still scheduled to go back to Texas?
No, sir. Everything's complete in Texas.
All right.
I have a job lined up. I have everything that I need to do to start my life. I apologize for what I did. I've been in jail for a long time, and I'm sorry. I'm just ready to start my life, sir.
And so all you're in jail for right now is a parole revocation hearing for having hit a fellow prisoner one time in the jaw.
Yes, sir.
Is that correct?
Yes, sir.
Everything else has been dropped.
Everything's done.
This bit.
Yes, sir.
Okay.
I'm ready to move. If you guys are.
I'm ready.
Mr. Coffey, my vote today is going to be do not revoke.
My vote is also to do not revoke.
Yes, mine is also do not revoke. It's 10:39 in the morning. Are you gonna stay away from it, fella?
Yes, sir.
How about if we put no contact on that?
Yeah.
What is the name of Mr. Como or something like that?
Gregory Como?
Yeah.
Okay.
You have no contact with Gregory Como.
Okay, that's a do not revoke with a condition that you have no contact with this man. Is that correct? Okay, and I will concur with that amendment, my vote. Mr. Tillis?
Yes.
Mr. Tillis concurs. So we're gonna not revoke you this morning, but don't have any contact with that guy. Stay away from it.
Yes, sir.
Okay? All right. As of 10:39 this morning, you're not revoked.
Hello.
Okay, the time is 10:56 in the morning. It's 3/3 of 2026 is the date. My name is Steve Prater, and I'm the chairman of the Committee on Parole for this morning. Jerry Ledoux is to my right, Chuck Tillis to my left. We're here to talk to Mr. Raymond Alexander. Are you Mr. Alexander?
Yes, sir.
Okay, what is your DOC number, Mr. Alexander?
281174.
Okay, and do you have a a revocation hearing waiver in front of you somewhere down there that you signed?
I just have parole board, parole revocation questionnaire.
Yes, sir, that's what I'm talking about. And did you fill that out and sign it? It talks about an attorney, an appointed attorney, or whether you were going to hire an attorney and that sort of thing. Did you sign that?
I signed the paper, yeah. The parole officer actually filled it out.
Okay, but you signed it.
Yes,
Okay,
sir.
and your attorney, I believe, is on the air with us. Is that correct? Mrs.
Yes.
Beth, would you say your last name, please?
Sure. It's Scrow. You say the G just like it's a C or something.
Okay, simple enough.
Yeah.
Okay, Ms. Scrow, and you're here to talk in favor and to represent Mr. Alexander. And Keisha Moss is going to be speaking, the fiance, and Terry Pierce with the Orleans Public Defender's Office is going to be speaking. Is that correct?
Well, as a threshold matter, we are all here and ready, but my intent today was to ask to continue this hearing for two reasons. And I mentioned this in my email. One is that we just, that the case is still in a sort of pending posture. As I noted in my memo, which unfortunately, I'm sorry you all just got yesterday. The case has been quashed, but the state has filed a notice of appeal and as far as I know is planning to appeal the court's ruling to quash the open case. And so because that case, because that appellate process is underway, I don't know whether there may be an open case returning to court in Mr. Alexander's matter. And so I've advised him that he's not able to talk about any of the facts surrounding that case because it's potentially going to be a pending prosecution again. And we'd like to be able to have this hearing outside of the shadow of that. The second reason, which I alluded to, is that I was only able to get you a packet yesterday because we had a pretty late notice of this hearing and we only found out about it about a week ago. And if we are to move forward, I would ask for a little more time to assemble some more documentation about plans for Mr. Alexander and employment prospects.
Okay, well, this case has been assigned to Ms. Jerry Ledoux, and she'll take over, leading the discussion. We've all got all of the reports and your request for the continuance. We have those included in our packet. We've all read those and are familiar with them, but Ms. Ledoux is the lead on this case, so I'll ask her to go in.
Thank you.
Thank you, Ms. Segrove. That I appreciate you being here and requesting that. The level of evidence that we need to make a decision regarding revocation doesn't rise to the level that a court of law will. We have a preponderance of evidence that we use as a standard for revocation. So just to note, Mr. Raymond Alexander is a parole case. He was paroled 3/18/20, and he's been detained on this from 6/18/24, and he has a good time date 6/2/41. It's been alleged that he has violated conditions 4, 5, and 10 of his parole. And I'm going to go ahead and read those allegations out. Very much like the preliminary hearing, he can vote guilty, guilty with the statement, or not guilty. And I think we'll go ahead and continue with the hearing today based on the evidence I have in my so if we can get Mr. Alexander. Yes, thank you. Mr. Alexander, you are accused on violation, just a minute. Violation number 4, that you were arrested by the New Orleans Police Department and for aggravated assault and convicted and a convicted felon in possession of a firearm. How do you plead on that?
Not guilty now.
Okay. Also, number 5 in your parole conditions states that you're not to have possession of a firearm. It was noted that when you were arrested, you were arrested for as a convicted felon in possession of a firearm. How do you plead?
I don't plead. I didn't understand you, ma'am.
You were arrested as a convicted felon in possession of a firearm. Were you guilty with a statement, or not guilty?
Not guilty.
And you're currently $2,248 in arrears for your supervision fee.
Say not guilty. For the last few years, outside of employment, you know, I've been unemployed pretty steady, but it's basically, you know, I've been taxes been paying it off.
Gotcha. Mr. Alexander, we're going to go ahead and listen to the other people who would like to speak on your behalf, and then Ms. Segre, you can have the time to follow up and close all the loops, if you will. Terry Pierce is Arlene's Public Defender's Office as well. Is he going to be speaking?
One moment, I'm sorry. He's dropped off the Zoom. He just texted me. He said he's been shut out for some reason.
Okay, I don't understand that. I'll let our staff know. Also, Keisha Moss, your fiance, will allow Ms. Moss to make a statement. Ms. Moss, if you're ready, I see him now. Yes, let Ms. Moss go.
Muted.
Oh, somebody had muted there. Good morning. Thank you for giving me the opportunity and the privilege to speak on behalf of Raymond Alexander. I am his fiance, Lakeisha Moss. Throughout this past year and a half that he has been there, this has been like one of the hardest moments in my life. Throughout our relationship, he has been like one of the best. I don't even know how to say. I'm just speaking. He has been one of the best persons that ever crossed me and my kids' life. He has been a wonderful stepdad to my kids who has no father. Their dad is deceased. He has took on a responsibility as raising them, giving them the opportunity to show, especially my oldest, how to become a man in life. He was the one that has blessed him, with the job when they was working together. He gave him the opportunity as in stepping out to talk to his supervisors into getting him the job and so working with him. They have grown such a wonderful bond. He also has stepped into the role as being a grandfather to my son who has 2 kids. The daughter that's not biologically his. He has been such a wonderful stepdad to her. And when I say the hardest, to hear my 8-year-old ask time and time again, when is her dad coming home? and not being able to explain this actually to her. To say I really don't know has been one of the hardest things. I can honestly say from the day I met him, he was one that went to church. If he didn't go by himself, we was going together. Um, I can honestly say from the day I met him, hardworking, he has always had that job up until the job has laid him off. And he was in the process of trying to find another one until he got into the car accident, which he had the job, but the lady kept refusing due to his back injury. This road has been so hard and so tough. He's not able to be there for his mom, who recently just had surgery, a major back surgery. And he was one that I have always known to always be there for her. Um, I, I'm trying to say it the best way I can, but I need him. Not just need him, me and my kids, this is where our life has begun, not as has been his fiance, but has begun to afford the step that, trying to plan a marriage, trying to rebuild, trying to get back to the things that we have lost. And I feel like another opportunity, just my opinion, shall be granted. Um, I don't, I'm sorry to know that this is the situation that stands at hand, but deep down inside, he has been the man that has shown me so much, that took me on my first flight out of town, that granted me so many things, that have shown me a different part of life. And not just me, also my kids. It's not easy, and it has been so hard to deal with. I can't ask for no more. I can't ask for no less. But the hardest thing right now is to mourn a person who is dead, but it's harder to mourn a person who is there that you cannot physically be with, not emotionally be with. And I'm just asking that he be blessed to be here with us again. That he's able to share these moments with the kids. That he's able to take her to where she need to be, to the dance and school sessions, to school, to be a part of the things he was a part of before. Not just only physically, but mentally. It's a mental thing. It's an emotional thing. It's many nights that I cry with my daughter and with my kids, trying to sit up here and figure it out and wonder why and how. My kids always say, I can't wait till he come home so he could take out the trash and, do the little things that's there, to be done that he has taught them.
I understand. I can, it is very difficult, and I do appreciate you communicating his value to you. We also have the Public Defender's Office, Terry Pierce.
Can I put it back on mute?
Yes, please.
Yes, good morning. My name is Terry Pierce. How y'all doing?
Well.
I've been knowing Mr. Alexander for quite a while. He's been working diligently. He's been free for over 4 years, and he's been working, having a steady job, paying his fees until things got bad, and they laid him and quite a few other guys off for economic reasons. And we have a program designed to help Mr. Alexander in terms of where all this derived from with the domestic issue. And we have a New Beginning Behavior Family Services program that's located in this building that have been working with us diligently in helping guys like Mr. Alexander to continue focusing on society and re-entering and moving forward. And we just like to ask this board to give him an opportunity to continue supporting his family and doing what's right in life. Thank you.
Thank you, Mr. Pierce. Mr. Gray, you can have some time to lay out the facts of the case in your mind, if you would like.
Thank you. Yeah, I appreciate that. I want, first of all, with respect, first of all, to formally ask that this board consider using its discretion not to revoke Mr. Alexander's parole, but to return him to parole with any conditions that the board sees fit to kind of solve for or correct for potential problems like the ones that have gotten him here. I think you've heard from Ms. Keisha how important Mr. Alexander has been to her family and how important it's been for her son to have a father figure, a role model, somebody to look up to as he begins his path in life as somebody who works and provides for his own. I won't go any further on that. On the allegations themselves, I would just note that the first one, the aggravated assault allegation, is neither the district attorney's office nor the attorney general's office has elected to prosecute that case. As I think the most important thing to say about it is actually contained in the parole officer's summary, which is the hearing officer summary, which is that that case has not been investigated. Now the hearing officer says, it hasn't been investigated, so we can't determine whether or not it happened. I would say that's equally relevant for this board, that allegation is the word of one person who describes sort of specific details about a weapon that aren't really in keeping with the distance and the darkness that this incident supposedly took place in. That there are sort of new allegations with no context or background or explanation of how they're possible that apparently emerged in her conversations with the hearing officer. I know that the burden here is only a preponderance, but I would just submit that the written allegations of a person who's never been subject to cross-examination, who's made allegations that never were tested in any kind of judicial proceeding, don't rise to that bar of even preponderance. With respect to the 95-1, as I've noted in my memo, and that's as to conditions number 4 and 5, as I noted in my memo, I think this board has the discretion to consider the reason that the case was quashed, which is that the restriction placed on Mr. Alexander with regard to firearms in statute, that is not really with respect to parole, was found by the trial court to be a kind of continuing harm caused by what's been found by courts across the entire nation to be an unconstitutional procedure. That is to say, a jury trial that didn't require a unanimous jury. I did provide the minute entry indicating that Mr. Alexander's original conviction for this charge that he continues to be on parole for was a 10-2 verdict. I would just conclude by saying that I want the board to note not just what folks have had to say about Mr. Alexander's 4+ years after his release, in which he managed to do a really incredible job building an adult life as somebody who'd spent his entire adult life up till that point in prison. But also to note that Mr. Alexander, since being incarcerated, has been attending programming in OJC, has been doing his best to take advantage of the limited resources that there are there, and has actively participated in planning for his own reentry while trying to avoid the kind of rampant violence and sort of everyday chaos that exists in OJC. More than anything else, this time that he's been incarcerated has made it clear to him that that environment is not for him, that he has grown into a man who's able to live in the world, having moved past the struggles that led him to be incarcerated in the first place and then to be on parole. So I would just suggest to the board that the solution to these issues that have come up for Mr. Alexander is not to revoke him for 15 years after 4 years clean and an allegation of handgun possession that doesn't involve any kind of use of the gun or violence or anything of that nature. But to allow him to return with the additional supports that Mr. Pierce has discussed, with the kind of counseling that will help him work through issues stemming from his past and continue on the course that he's begun to chart for himself, but with the support that he's ready to recognize he needs from his legal team, from his family, from his community, to make sure that he does not appear in front of this body again.
I appreciate those comments, and we do have a copy of your packet, and I have reviewed it. I'd like to make a motion to go into executive session.
I'll second.
Okay, a motion and a second to go into executive session. There is no objection to that. It's 11:17. We'll be going to executive session just a few moments, and then we'll be back. So. Okay, it's 11:22 on 3/3 of 2026, and the board has been in executive session. Can I have a motion and a
Make
second?
a motion, we move back into regular session.
Got a motion and a second to move into regular session, and there is no objection to that. So we're in regular session now again, as I said the time, 11:22. Okay, Ms. Ledoux is,
Yeah, so, Mr. Alexander, I am reading the report of our probation and parole officer taken from the law enforcement investigation, which indicates clearly that a search incident to arrest revealed that Raymond Alexander was in possession of a .40 caliber Smith & Wesson pistol, which was fully charged and had 14 live rounds in the magazine. The firearm was recovered from Raymond Alexander's front waistband after Raymond Alexander acknowledged that he was in possession of a firearm. I am not even going to deal with the domestic abuse issue. The conditions of parole, whether it's, the whole issue, thank you for bringing it up, about the 10-2 jury and all of that's going to be resolved in litigation later. You knew you were not supposed to have a firearm. Law enforcement indicates that you were in possession of a firearm. My vote today is to revoke parole.
Also, my vote is to revoke rule number 4, 5, and 10.
and I concur with that. 4, 5, and 10 are the conditions of parole that you are, have violated. So as of 11:25 this morning, your parole has been revoked.
I don't know why.
Okay, the time is 11:31 in the morning. My name is Steve Prater. To my left is Chuck Tillis. To my right is Jerry Ledoux. And we're here to talk to Mr. Gary BREAUX. And Mr. BREAUX is in Orleans Parish Jail. We've already talked to the folks at Orleans Parish. So, Mr. BREAUX, what is your DOC number?
2529710.
Okay, and I understand and know, and on Zoom also is your attorney, but you have a waiver form in front of you where you signed that you were ready for this hearing. If your attorney, and that you wanted your you wanted your attorney here, and your attorney is on Zoom. So are you ready to proceed? I'm gonna turn it straight over to the attorney in just a second. But are you ready to proceed with so far what we've done?
Yes, sir.
Okay, Mr. BREAUX, would you go ahead and before we go any further, let's go ahead and have you make a statement and tell us what's going on.
So, and I'm sorry for jumping in. The answer to your question is that I don't have any idea what's going on. I'm actually just standing in for Mr. BREAUX's assigned attorney, who is Michael Gregory. He asked me to stand in for him because he is in a jury trial at this moment. He's actually about to deliver an opening statement, and he asked, since I would be here anyway, if I could convey that to the board and ask for this to be rescheduled for the next available setting.
Okay, and just for your clarification, I'm inclined, my vote is inclined to continue this. I don't know what my other board, I think there's a leaning toward continuing this. And I just want you to understand the difference in this particular case as compared to your case. In your case, there was, in our view, there was and I don't want to get back into your case, but there was a preponderance of clear evidence about the firearm. Okay, in this particular case, it's not as clear having reviewed. And so we would like to continue it and possibly until the court case is resolved, but not necessarily that long. But I think that we would be lean towards continuing it. And I just wanted to go that extra step to explain to you what the difference in the two cases.
Yeah, I appreciate that. I did look up Mr. BREAUX's court date in anticipation of this. It is set April 7th of this year.
Okay, well, is the board ready to vote?
Yes.
Okay, and I was the lead on this case, so my vote is to continue this case. And Ms. Ledoux?
My vote is to continue this until the disposition of charges.
I also concur.
Okay, so we have 3 votes to continue this case. And so the continuance is granted as you requested and as the board saw fit. And we thank Miss, let's see, Miss Kelly. Miss Kelly, thank you for being here. I won't try the name. I'm not good with names, but thank you for being here on Zoom, and we've decided to continue this case.
Thank you.
Okay, that'll be the end of this at 11:35. Okay, good morning, still morning. It's 11:43 in the morning. My name's Prater. To my left is Chuck Tillis. To my right is Jerry Ledoux. We're in Baton Rouge. We're going to have a revocation hearing on Mr. Lionel Davis. Is that you, Mr. Davis, that I'm looking at?
Yes, sir.
Okay, what is your DOC number?
118554.
Okay, do you have a waiver in front of you that talks about this hearing, and did you sign it and understand it?
Well, I didn't sign any papers.
That's right. I'll take it.
Okay, well, I'm gonna turn your case over to Ms. Ledoux to my right. She's the principal on this case, so Ms. Ledoux.
So, Mr. Davis, you refused to sign and you refused to participate in the hearing. Was that correct?
Yes, ma'am, I did. And I have reasons for that, and I'm gonna wait until you give me the opportunity to state my reasons.
Okay, in the preliminary hearing, they brought out all of the statutes and regulations regarding your crime and went through those, didn't they?
Well, again, I didn't even entertain the officials, and I said, when you give me the opportunity, I will explain why.
Okay, so are you currently receiving treatment for any mental illness?
No, ma'am.
Okay, can you read and write?
Yes, I'm in college as we speak. I was taken out of college for this purpose.
And so you're willing to speak on your own behalf. Are you currently have any addictions that would interfere with your ability to understand the proceedings?
No, ma'am.
Okay, so based on that questionnaire required by the Supreme Court, I find that you are not eligible for appointed counsel. So you were you've been charged with violating the conditions of your parole. And let me get you that. Yeah, I'm gonna what's up here. You did not report to the New Orleans Police Department Sex Offender Registry Office to register in accordance with Louisiana RS 15542. So just give me your plea of guilty with a statement, or not guilty, and then I'll give you the opportunity to elaborate. Okay?
Guilty. And if I could, I want to make an objection to that scenario, if I could. And I want to base my objection on, again, when you give me the opportunity to speak about what I want to speak about.
Now is a good time, sir, for you to go to your justification.
Okay, for number one, the records will reflect that I was never informed by any trial court that I had to register as a sex offender. I was initially convicted for armed robbery, first-degree robbery, and I was sentenced to 20 years. While serving that sentence in Orleans Parish Prison, I caught this offense. 1990, October the 25th, 1990. From 1990 to today, no court has advised me that I had to register as a sex offender. I was, as a condition of my supervision parole in 2001, I was informed by Department of Correction that I had to register as a sex offender. If my records would also reflect that I refused to do that when they went to putting the sex offenders on the identification cards, and I stayed in prison for the remainder of my full-term date. My argument is really based upon Morrison versus Brewer, which guarantees me that certain due process safeguard will be afforded to me at this hearing. Louisiana revised statute. My forcible rape conviction is defined as a sex offense under 15.571, 15.541, 14.1. Louisiana 15.542 outlines mandatory registration requirements for sex offenders. In addition, Louisiana revised statute 15.543A mandates that the court notify a defendant charged with a sex offense in writing of the registration requirements of Louisiana revised statute 15.542 as follows. Offenders notification, the court shall provide written notification to any defendant charged with a sex offense of the registration requirement of 15.542. Such notice shall include any guilty plea, should be included on any guilty plea, form, judgment, or sentencing form provided to the defendant. My argument is centered around Morrison versus Burger. In State versus Parish, the Fifth Circuit Court of Appeal has held that like the omission of Louisiana Code of Criminal Procedure, Article 930.8 notification. This omission warrants a remand for written notifications, and the court generally remands with an order for the trial judge to inform the defendant of the registration requirement as provided in Louisiana Revised Statute 15.543.8 by sending appropriate written notice to the defendant within 10 days of the court's opinion and to file written proof and in the record that the defendant receives such notice. I have never received a notice from anyone that I am a sex offender. And
I have here in my file, Mr. Davis, a form that you were given on 10/21/25, and it says notice to sex offenders, and it has your name, and it has a witness. It has your DOC number, your name. Everything is right here in front of me.
That notice from the Department of Correction, from RAYMOND Correctional Center, has a UD in front of it. The reason I put the UD in front of my signature is because if you would look at 15.542.1, is entitled a registration for sexually violent predators and child predators. And that statute, it specifically says, any person convicted of a sex offense as defined in 15.541, 14.1, or as a criminal offense against a victim who is a minor as defined in 15.541.9 after July the 1st, 1997, to have the duty to register and report under the provisions of this chapter. It also gives the Department of Correction the authority to give people after July the 1st, 1997, the authority to register, to issue notification to those people instead of the court. That's 97. I was convicted in 1990, October the 25th. I wasn't convicted after 97. I was convicted October the 25th, 1990. Don't have nothing to do with me. The department cannot advise me to register as a sex offender. And I mean, I'm in college. I am your first criminal justice expert in the history of the United States. I understand where.
If I may intervene, if that's okay.
It's on you, man.
So, we speak as Boris Drain, the paralegal for the Orleans Public Defender Office. Is that correct?
Yes, ma'am, that's correct. And first of all, I'd like to say good morning, Ms. Ledoux, Mr. Prater, and Mr. Tillis. And this case in particular isn't your usual parole revocation hearing. And what Mr. Bailey is saying is that he wasn't given a clear notice or a clear guide on how to even go about the registration process or how to even comply. Mr. Davis, these particular charges, well, he was convicted about 40 years ago. I think the offense happened in 1986. I want to say he was convicted a short time afterward. But the law he's referring to came about in 1997. And what he's saying is that it doesn't retroactively apply. And to my understanding, the way that I look at this, just from a human set of eyes, just humanizing Mr. Davis in this situation, he's been incarcerated for 30 to 40, close to 40 years. And we all know, like, once you're institutionalized, the way that you think, the way that you function becomes a part of the institution. So with the law being updated in 1997, Mr. Davis didn't actually have any way of knowing how the law was updated, how it was changed, or even how to comply. And I do want to, I wrote something on his behalf. I'm going to read it real quick while we have the time. Members of the board, before a single fact is weighed or a single argument is considered, the board must first understand what kind of proceeding this is. And it's not your typical parole revocation hearing, and it should not be treated as such. Usually in a standard revocation proceeding, the board considers a violation that has already been adjudicated. And I want to note here, this particular charge happened in 2021. So Mr. Bailey has been out for about 4 years. He's been taking care of his mom. He hasn't, shown any characteristics of somebody that doesn't want to willfully comply. He's, to my knowledge, and as you can see, like, he understands what he understands about the law, and being institutionalized, being behind the bars 30 to 40 years, I feel like the judge.
Excuse me, brother.
Go ahead, Mr. Bailey.
Let me tell you how this went, man. This is my freedom, bro. Let me tell these people how this went. I went to trial for failure to register off of the registration I made in 2001. This is how they established that I failed. They say I knew I had to register off of the condition that I was sent out of prison on in 2001. No court has told me that I had to register as a sex offender. It's in my records. It's clear. I'm not institutionalized, man. I'm not going to live here and let you.
I will add to that.
Let me tell these people about my freedom, man. I ain't got no. I'm not. Man, listen. I'm telling you that nobody has told me. You want to know my reason for refusing to register? I'm trying to explain to these people my reason for not registering, man.
Yes, sir.
Nobody has told me. I did it as a condition of my supervision release.
So you were not notified, and that's what we were telling the board, that you were not notified by a judge that you had to register.
Okay.
And
I can't do that, man. Okay.
You were given paperwork upon your release that you signed that indicated all of the conditions of your release as a sex offender. At that time, if you had problems registering as a sex offender, that matter should have been taken up immediately. You were detained a month later. You had, at that time, you signed that you understood registration was a condition of your parole. Okay, you refused to do that. I'm not going to entertain the arguments. You were given the information, regardless if it was by the court system or DOC. You knew the obligation by the Department of Correction for you to be on parole was to register. You have a full term date coming up, April 19th, 27, minus the amount of time that you've been detained. I mean, in addition to the amount of time you've been detained, but you failed to register, and that was a requirement of your parole. The discussion about who should have given it to you and all of those issues should have been addressed with your probation officer at the onset of the supervision, not after you got in trouble for it.
Now to tell you, I gave my parole officer a copy, and I
And
also
elevated it beyond the parole officer if that was what needed to be done.
I mean, he didn't act on it. He come in my house and arrested me.
Miss Ledoux, if I could intervene once more. I'd like to say, from what I'm looking at this, from my point of view, this isn't a case of willful non-compliance. This is a case of, an individual who's been incarcerated for nearly 40 years. And that's a fact. I mean, he's lived through changes in society, changes in technology. When he got incarcerated, there was no online portals. There were no cell phones. It was not a digital empire that, is easily accessible as it is today. There's no internet, no smartphones, no email, no social media, no online job portals. This is someone who's trying to get back into society. This is someone who just needs to understand the process. And as you can hear, and what Mr. Bailey is arguing is that from his point of view, this is what he understands.
Yeah, but I'm pointing out that he has been told. Now, Mr. Drain, if you're going to assure me that you're going to walk with him and get him registered, then that's a different issue. But the fact that, according to our report, he is required to register and he has refused to. Okay, I have to go according to what the evidence shows me.
So you're telling me you?
Yes, ma'am, and I understand, and I do wish to respect.
Excuse me, Mr. Rain. So I'm
Go ahead,
saying
Mr. Bailey.
I'm saying so. Excuse me.
Mr. Davis, you let him please finish his conversation. Just let him finish, and then we'll get back to you.
Yes, ma'am, and I understand. And me and Mr. Bailey have, we've gotten to know each other through the past weeks, and it's sort of like, it's been the exchange of case law after case law, and me just trying to get him to understand how the law works. I mean, there are times when, he's on board with me, he agrees with what I'm saying. There are other times when there may be another avenue that even I have to explore myself, because his presentation of the argument is pretty in-depth, and he refers to case law. And what I will say is I want to respect the autonomy of Mr. Davis. I want to respect his dignity. I know, and I told him that you guys are doing y'all's job. I mean, you're looking out for public safety, and I told him that he would have to eventually register. And there was a point in time, I'm not sure if he's still on board with that. He's willing to comply. I know that he has a mom that he takes care of. She's elderly. He has a son. And like I said, within the 4 years that he was out, there was no extra violent charges. It's just the paperwork. And if I may, it's like I said, I want to protect Mr. Davis. Mr. Bailey is his nickname. I want to protect Mr. Davis' dignity. So ultimately, it's up to him. But if necessary, I'll do everything in my power with the resources I have with Orleans Public Defense to help Mr. Bailey follow all of the guidelines that he needs to, and I'll help him be compliant.
Okay.
But it's ultimately.
I mean, I wanna get an understanding of this, man. And this is something that, I mean, I had 10 years for forcible rape in 1990. We're in 2026. I had 20 years for a robbery. I mean, and I was really under the lead and the pain versus the state. Expo factor thing. This was my concept at the time. But after being informed by Mr. Durang that the Supreme Court overruled that, and they said that it was a punitive, a punishment thing, right? I can't seem to understand how a 10-year sentence has been changed to a life sentence. I got life registration.
Okay, so right now, listen, you're extremely intelligent. I bet the two of you together are have some very engaging conversations. But right now, what we need to decide is the law requires you to register according to our understanding of what we have today. And so I don't want to put you back in jail. I don't want you to stay in jail over just registration. That's not what I'm going to do. But you have to register. So if you can, if you can attend.
I'm not going to register. That's what I'm telling you. I'm not going to do it. I'm not going to do it.
Ready to vote?
Then we're gonna vote. Okay, thank you. So today, based on your non-compliance with registration, which is required by law, my vote is to revoke your parole.
And I concur.
Yes, sir. As I concur. As of 12:03 in the afternoon, your parole has been revoked for your refusal to register.
Thank you, sir. I appreciate you, man. I'm not going to do it, man. I appreciate you.
All right, Mr. Bailey, have a good one. I'll come see you soon.
All right, Mr. Parker. My name is Steve Prater. We're in Baton Rouge. The time is 12:08. It's still 3/3/2026. To my right is Terry Ledoux. To my left is Chuck Tillis. We're here to discuss your revocation of your parole. Do you have a questionnaire in front of you? I think you might be on mute. Do you have a button you can push there? Can you say something so we can hear you? Nope, you're on mute still. You dial a friend there or something.
Hello, can you hear me now?
Okay, we can hear you now. You are Mr. Tracy Parker, is that correct?
Yes. Yes.
What is your DOC number?
242773.
Okay, and do you have a questionnaire in front of you talking about this hearing that we're fixed to conduct?
Yes, I do.
Okay, when you get out of, did you sign that? Did you sign that questionnaire?
Yes, I did.
And you understood everything that was on it, correct?
Yes, sir.
Okay, when you get out of jail, you agree to abide by certain conditions. Some of these conditions you are suspected of having violated. We'll go over these conditions right quick. Rather than read each and every one of them, there's condition 2, 3, and 6, which means that you will have monthly reports to your parole officer, that you will tell them where you live, and that you will tell them where you work, and you will keep them updated on all of that. You're accused of not having kept them up to date on all those things. Since 2022, I believe, they got a warrant for you, and they did not find you until you were arrested in 25, the end of 2025. So that's almost a little over 3 years that they didn't know where you were. Are you guilty of that or not?
Yes, I am. I take full responsibility of not living up to my obligation to when I was granted diminution of my sentence in 2018. I'm not here to make any type of excuse of me failing to report or initially find out where probation and parole was located in New Orleans, because when I was granted parole, I was living in Homer, Louisiana, and I wound up finding work in New Orleans, Louisiana, to where it became difficult for me to be going backwards to New Orleans and to Thibodeau to maintain a job. So I had asked for a transfer, and then the transfer to New Orleans, we lost contact. We had stayed in contact with each other through the telephone. We was they made sure that I text them and like that. And after having this preliminary hearing, I realized that the COVID situation during that time had transpired. Again, understanding I'm not using that as an excuse, because I have admitted it's my responsibility to allow my parole officer to know, even though we had lost contact through the text message and stuff, my whereabouts.
Okay, all right. And then violation number 10, condition number 10, you owe $3,989. Is that correct?
Yes, I does. Yes, I do. And at the time I was allowing, I had spoke to my parole officer behind that. They was garnishing the month, instead of me paying monthly, they was taking it out of my my income taxes. and again, due to my lack of responsibility, I just lost contact and failed to continue on to my obligation to allow him to know that I had got hurt at Richard's disposal and the swelling on my ankles and my foot. I had injured my foot to where I was out of work for like a year and a half due to my foot and my varicose veins in my legs. However, now that I'm back healthy, my foot is I was gonna lose my foot, but I didn't lose it. So I'm trying to work my way back into getting work and employment. Again, I initially take my responsibility of my lack of duty, which is something that's very unreal myself, because prior when I got parole, I was doing my best. It's just that I fell off. I took my initiative of not holding up to my obligation.
Yes, sir. I appreciate that. And we really appreciate you taking responsibility for that. And, you know, it is a shame you lost your hindsight, but you know, that happened and we don't know what to do. I mean, anyway.
He's admitted to,
Okay. All right. It's my case and I'm supposed to vote first. So my vote is to revoke your parole. Can't stay gone for 3 years without us being able to find you. And if you ain't abide by the small things, you want the big things. And anyway, that's my vote. Mr. Tillis?
I concur.
My vote is to revoke based on absconding.
Okay. As of 12:15 this morning, your parole has been revoked. And I'm sorry and wish you much luck in the future.